Welcome to DJ TV.
My correct people, greet you now. Welcome now once again to DJ TV. Yes, so my people, not be small thing though. Una know say Labour Party dey complain since say the certified true copy of the judgment wey Supreme Court give say they never see am o. Right now, Kenneth Okonkwo don come out, don come talk say they don receive the CTC copy for Supreme Court judgment o. But im talk a lot of things concerning that certified true copy wey be say Supreme Court don say im give dem like this o. According to wetin e talk, e say some things dey for inside that certificate so wey be say e no dey for the judgment wey Supreme Court give on the day of judgment o. E say because dem dey see different things and na different thing dem hear for court. E say this one e dey against the law of Naija o. Anyway, my people, I no go talk too much. I upload na this video. Una hear from Kenneth Okonkwo wey be lawyer, activist and spokesperson of the Dissolve Obidanti campaign. Una watch and make una no forget to like and share. Make una watch the video.
Oh well, let me confirm that we received the CTC of the judgment. Our legal team alerted us to this. Let me also confirm that the lead judgment as delivered by Justice John Inyango Koro was exactly what he announced at the court. And then, while saying this, it will be important to educate us on what constitutes a legal and constitutional judgment by any court. First of all, the court has no power to insert in its written judgment any decision that it did not announce in the court. And I'm talking about section 36 subsection 3 of the Constitution of the Federal Republic of Nigeria. If a court does that, it has egregiously infringed on the fundamental human right of a party to fair hearing. The section provides every proceeding of the court, including the decision of the court, shall be announced in the open court, and that's pronounced. Then, by section 294 subsection 1, every decision of the court must be in writing, meaning whatever you are pronouncing or announcing in the court must have been in writing. And after that, the court becomes functus officio. You do not have any right to add or remove anything on it. I want to point out also that any court that is constituted by more than a judge means that the decision of the court will now be done by majority of the members. The Supreme Court was constituted by 7 judges in our appeal, and the leading judgment was very clear. They said every issue in Obi's case has been, according to Justice Muhammad Lawal Gaba, he said, has been comprehensively, completely, effectively, and totally dealt with in Atiku's case. And there was no reason for them to reiterate anything again. That was what Justice Inyang said. And he even went further to berate the appellants that they ought not to have even brought issue 4, because according to them, in the earlier case of PDP and INEC, they have taken decision. Now, reading the entire CTC judgment of the 7 judges, I was surprised to see some issues in the judgment of 3 justices of the Supreme Court that was not announced in the court. I was there in the court. The issue of forfeiture of $460,000, which was proceeds of narcotics. Now, this is the Broadway judgment goes. In any judgment that involves majority of judges, they must sit before the judgment day. They will elect the person that will write the leading judgment. And in that leading judgment, all issues must be decided. And it is when more numbers of the judges concur to the issues, that is how leading judgment comes. Now, those 3 judges that wrote the forfeiture issue, in their judgment. Where did they get that issue from? Because it was never mentioned in the leading judgment. Because you either concur or you dissent. Now, assuming without conceding that they even announced it, 3 justices, they are minority. Because it would have been better they didn't even mention anything about it. So does it mean now that the majority of the judges have now ruled against the 3 judges? So this judgment, as far as I'm concerned, broke every issue of the ingredients of a judgment of a court.
Well, you know, you were in court. You were part of the legal team, so you know better than me what happened. I'm looking at that certified true copy that they sent to you now, because we have it. It says that the 7 issues raised and canvassed by each of the 2 appellants in their respective briefs or arguments are not only identical, but materially and substantially and essentially the same.
Absolutely.
Right.
They even call it sister appeal.
Right.
And these are the 4 judges that upheld this perfectly and accurately. And I'm talking about Justice John Inyango Okoro. I'm talking about Justice Saulawa. I'm talking about Justice Tijani Abubakar. And I'm talking about Justice Mohammed Lawa Gaba. 4 of them. Then the other 3 justices, I do not know where they got the issue of forfeiture from. That is an insertion. And that is very dangerous. Because, like I said, it is illegal and unconstitutional for you to insert in a written judgment a decision that was not announced publicly to the court. So the 5 criteria for you to judge a judgment: 1, it must have been announced in the court; 2, it must be written; 3, it must be in public; 4, once the court is done, the court is functus official. None of them. Then 5, but after the judgment, 7 days is what the court has to give the copies to the parties. It was not done. None.
Right. But what about the lead judgment by John Inyang Okoro, which said at the end of it that on the whole this appeal lacks merit and is hereby dismissed?
Absolutely.
And the appeal is dismissed. I mean, does that comprehensively cover it?
No. The issues of forfeiture and some other issues we are not mentioned at all in the appeal of article. So there's no way it could have been comprehensively dealt with.
So what happens now? Is there a process for seeking clarification and possibly rectification and restitution?
Now, the Chief Justice of Nigeria ought to summon an emergency meeting, because this has impugned the character of the judiciary worldwide.
Yeah, but what I mean is are you going to apply for that? Are you going to write to them to say, well, these are the discrepancies and we demand, because let's face it, that those justices are supposed to deliver justice, and you have a right to ask and ensure that that justice is delivered.
Good. Without prejudice to further actions that we may undertake, recall that the decision of the Supreme Court, unfortunately, is final by Section 235. But as a minister in the Temple of Justice, I am worried that this kind of judgment should never be a precedent in Nigeria. And the Chief Justice of Nigeria has the duty and the right to proclaim it as such.
Yeah, but would you request of him
to do that? We don't need to request it. In 1979,
or draw his attention to
in 1979 or thereabout,
right,
the Supreme Court gave a judgment in the Shagari presidential issue, and they even announced in the judgment that this should not be taken as a precedent. And it is very sound in law, because Montesquieu, the father of spirit of laws, made it clear. He said a precedent can only be established when judgment is conformable to the dictates of the law. That is the only time you can fix a judgment and say it should be a precedent. And he warned that if you do not give judgment based on law, then it will become the opinion of the judges. and there is no way the people will know exactly what the obligations are.
Hey my people, not be small thing o. Una hear wetin this man talk concerning this whole matter, judgment of Supreme Court and all. Make una see this whole matter, na reason am. Make una drop una comment o, and make una no forget to like and share. DJ